Okay, everyone. I hope people can hear me. I think we'll get started. I wanted to let everybody know that this afternoon's talk is going to be recorded and it may be shared publicly in future, so please bear that in mind. Good afternoon, everyone, and welcome to the 2022 Merv Leitch QC Memorial Lecture. My name is Barb Billingsley. I have the pleasure of being the Dean of the Faculty of Law at the University of Alberta. Thank you for coming. This lecture has been an annual event since 1991, jointly hosted by the Faculty of Law at the University of Alberta and the Faculty of Law at the University of Calgary. We are very pleased to be continuing this tradition with this year's lecture being delivered by Senator Paula Simons, one of our country's most well-known, well-spoken, and publicly engaged senators. Because we are all still in the phases of coming out of the pandemic, this year's event is being held virtually. However, I want to begin by acknowledging that the host institutions, the University of Alberta and the University of Calgary, are located on Treaty 6 and Treaty 7 territory, respectively. Senator Simons is delivering her remarks from Ottawa, land of the Algonquin and Anishinaabe Nation. We respect the histories, languages, and cultures of all First Peoples of Canada. There's several people that I need to thank in respect of this event. In addition to many of our colleagues who are working behind the scenes, I want to thank, of course, Senator Paula Simons for agreeing to speak with us today. I want to thank Dean Ian Holloway and the University of Calgary for partnering with us to organize this event. Thanks and congratulations to the students who have won the Leitch Scholarship Awards. Many of those students are with us today, and some of them will be moderating the question and answer period following Senator Simons' remarks. And finally, very sincere thanks, of course, to the members of the Leitch family who continue to participate in and support this event year after year. I now will turn the floor over to my collaborator in this event, Dean Ian Holloway, to offer his greetings.
Thank you very much, Barb. Friends, let me begin by echoing Barb and welcoming you all to this year's Leitch Lecture and offering thanks to all of you for coming, and special thanks to you, Senator Simons, for agreeing to speak to us today. This is, without question, an event that is important to all of us, but in a way, it's an event whose importance is only growing with each passing year. I had occasion to say to a group of people earlier today that perhaps counterintuitively, the longer we get from Mr. Leitch's passing, the more critical this becomes. And that's because one of the things that we're seeing in society seems to be a deterioration in the kind of standards and ethics of public life that was so well exemplified by Mr. Leitch and Premier Lougheed and all of those great people who came together to make Alberta the province that it is today. And so that's why we're so delighted to be continuing in the celebration and memorialization of Mr. Leitch's legacy. And it's also why I'm so proud that we're able to continue to do this in partnership with our friends at the University of Alberta. This is very much an Albertan event, not a Calgary or Edmonton one. I want to echo Barb as well by expressing my thanks, my continuing thanks to the Leitch family, without whom this would not have begun in the first place, and certainly without whom it wouldn't be continuing in the extraordinary way that it is today. And one of the things that the generosity of the Leitch family allows us to do each year is to celebrate the accomplishments of a group of students. And so I want to congratulate all of those students who've won Leitch Awards, both at the University of Alberta and at the University of Calgary. Bravo to all of you. And now I'd like to introduce someone who is a graduate of our law school, but who happens to work in Edmonton, fittingly. But more importantly, he's also a child of the person we're honoring today, and that is Mr. Jim Leitch. Jim?
Ian, thank you very much for those kind remarks and your remembrance of Dad in particular. Our family thanks you and Dean Billingsley and the staff of the two faculties. Yvonne, Peter, Caitlin, and Tim in particular this year, but undoubtedly others behind the scenes, for the ongoing partnership between the two faculties and the administration of the scholarships and the organization of this lecture series. On behalf of our stepmother, our dean, my sisters Jan and Kathy, and our sister-in-law Glenda and their families, welcome to all looking in, and thank you for your interest. I think it'll be very interesting. I think among others, there might be some members of the Lougheed family looking in, and perhaps our family overseas, and a special welcome to them if so. Hopefully we can return to a hybrid in-person and virtual events soon, but that's a small matter given everything that's going on around the world these days. We're very pleased to have the Honorable Senator Paula Simons as our lecturer this year. And our thanks to you, Paula, for agreeing to be so. And I'll have a few more things to say when I have the privilege of introducing you shortly. Congratulations, as always, to the award winners. Every year I feel a bit more inadequate when I read their bios with their academic prowess, but also their community and law school service. So we wish you all the best, and perhaps we will meet you down the line somewhere. I think Senator Simons will be remarking on some notable anniversaries in the law of our province and nation in her remarks, but I just want to note two particularly personal ones for us this year. The first is a bit sad, but coming up 10 years this fall is the passing of Peter Lougheed, which was a loss on a national level and provincial, but also personal, most notably, of course, for the Lougheed family, but also to us, given the long friendship of Mr. and Mrs. Lougheed and our parents and others. So we share in that loss. But the other is much happier, and what might be called the pre-genesis of the lecture series, among other things. 75 years ago this fall, our parents, Joyce Morris and Merv Leitch, and Peter Lougheed, arrived separately at the University of Alberta to continue their academic careers. And they were joined and they entered what was then offered as the 5-year BA LLB program. They were joined the following year in the fine arts discipline by Jean Rogers, who would become Jean Lougheed. And that commenced a series of lifelong friendships, not only between those four people, but also many who were at the University of Alberta at that time. And in fact, of course, for my siblings and I, we might not have existed except for them all coming to U Alberta. And on the subject of thanks, here comes my annual commercial for Peter Lougheed. Not that he really needs it, but every year our family, and Ian, you alluded to this as well, receives very warm and complimentary thanks from the award winners for the awards and the financial amount with that. But just to clarify, those thanks in terms of the source of the funds are due to Peter Lougheed and those people that he enlisted to donate to fund this lecture series and the scholarships at the two universities because of with Dad's input, because of Dad's connection to both universities and their faculties and the cities. So we will, of course, continue to accept those thanks on behalf of the Lougheed family, but just if you want to give thanks, if you spot one of them at some point, that's where they should go. And now, my final pleasurable duty to introduce the Honorable Senator Paula Simons. Senator Simons was born and raised in Edmonton and holds a BA honors degree from University of Alberta and a master's degree from Stanford. Before that, however, like me and my siblings and a number of the Lougheed kids and probably some other people looking in, she was also an attendee of Ross Shepherd High School in Edmonton. We were there at the same time, I think, but I don't think we saw each other much. Senator Simons was appointed to the Senate in 2018 as an independent senator. I think many of you, of course, will know of her work as a journalist and a commentator, especially those in Alberta and probably especially Edmonton, but now on a national level. She's been a radio documentary maker, a playwright, an author of popular history, but again is best known for her political columnist work with the journal. Over her 23 years at the paper, she earned 2 national newspaper awards, 1 for investigative journalism, and 1 for column writing, and a further 6 National Newspaper Award citations. She's been recognized with awards from UNESCO, the Canadian Committee for World Press Freedom, Journalists for Human Rights, and other organizations. In 2021, she was nominated for her first National Magazine Award for her regular column On Second Thought, which appears in Alberta Views magazine. And she also, as some of you will likely know, is the host of her own political podcast, Alberta Unbound. She's the deputy chair of the Standing Senate Committee on Agriculture and Forestry and a member of the Standing Senate Committee on Transportation and Communications, and served as a member of the Standing Senate Committee on Energy, the Environmental and Natural Resources. So with that, it's my pleasure to welcome Senator Simons to be this year's Leitch Lecturer. The floor is yours.
Thank you so much, Jim. Jim is too kind to say that he was way cooler than I was in high school. And the reason he didn't know me is that I was very busy being on the Students' Union and reach for the top teams. And he had cooler things to do. So, but thank you very much, Jim, for that kind introduction. My lords, my ladies, Dean Billingsley, Dean Holloway, and members of the Leitch family, and all of you watching from wherever you may be. Hello, bonjour, and tansé. I'm honored to be speaking with you today from our nation's capital on the traditional unceded territory of the Algonquin Anishinaabe people. I am especially honored to have been invited to give this year's lecture in honor of Merv Leitch. I never had the chance to cover Mr. Leitch as a politician when I was still a high school student when he left politics. But my father was a lawyer and a graduate of the U of A Law School. And at our place, Merv Leitch was a household name because of his commitment to civil rights and to Alberta's economic future. Along with colleagues like Peter Lougheed and Lou Heinemann, he helped to pull this province into a new modern era of optimism, prosperity, and political courage. He created Alberta's first Bill of Rights in 1972. He helped this province take a leadership role in Confederation and helped broker the deal that led to the repatriation of the Constitution and the creation of the Charter of Rights and Freedoms, complete with Merv Leitch's compromise brainwave, the Notwithstanding Clause. This year, as we mark the 50th anniversary of Alberta's Bill of Rights and the 40th anniversary of the Charter, I wanted to talk about constitutional history and about what it's like to find myself in the midst of making it. Don't think of this so much as a conventional speech or lecture. After all, I'm a storyteller, not a professor of constitutional law. Think of this instead as a series of stories, overlapping, interconnected stories, nestled inside each other like those Ukrainian nesting dolls that are so much a part of our Alberta heritage. Let's open the first doll, planting a living tree. Every time I enter the Senate, I pass statues of 5 remarkable, redoubtable Alberta women: Emily Murphy, Nellie McClung, Irene Parlby, Henrietta Muir-Edwards, and Louise McKinney. Louise McKinney was a teacher, preacher, and temperance crusader, and the first woman in the British Empire to serve as a member of a legislative assembly. Irene Parlby was a rancher in central Alberta who became Alberta's first female cabinet minister. Henrietta Muir-Edwards, the oldest of the group, was a journalist, social crusader, and publisher, and the doyenne of Canada's suffrage movement. Nellie McClung was a novelist and journalist and an Alberta MLA. Emily Murphy, another crusading journalist and author, was one of the first women in the British Empire to serve as a magistrate. They did not share the same politics, nor the same party. Murphy was a conservative, McClung a liberal. Parlby belonged to the United Farmers of Alberta, a sort of forerunner of today's NDP. Edwards and McKinney, like me, were independents. But one day in 1927, they met at Emily Murphy's house for tea, just a few steps from the University of Alberta Law School, and agreed to join forces to argue before Alberta, Canada's highest court, that women had the legal right to serve in the Senate of Canada. To do that, they had to argue that women in Canada were legal persons, not just in terms of pains and penalties, but in terms of rights and privileges. They lost. This is perhaps not surprising when you consider the character of Canada's Chief Justice of the day, Sir Lyman Poor Duff. Yes, that was his name. I'm not making it up. Sir Lyman Poor Duff was a stickler for precedent and for the strictest of strict interpretations of the black letter law on the page. The judicial function in considering and applying statutes is one of interpretation and interpretation alone, he once wrote. The duty of the court in every case is loyally to endeavor to ascertain the intention of the legislature and to ascertain that intention by reading and interpreting the language which the legislature itself has selected for the purpose of expressing it. Well, those 5 Alberta suffragists weren't about to bow down to the literalism of Sir Lyman Poor Duff. They appealed, as one could in those days, to the Privy Council in London. And here's where we come to an important accident of history, a constitutional coincidence. In June of 1929, Ramsay MacDonald, one of the founders of the British Labour Party, had won a general election, though not by very much, and had become Prime Minister of a minority Labour government. MacDonald appointed a progressive lawyer and human rights crusader named John Sankey as his Lord Chancellor. Now, Sankey didn't come from a noble or landed family. His roots were thoroughly middle class. But Ramsay MacDonald made him a baron and put him in charge of Britain's legal affairs. If the person's case had arrived in London just a few months earlier, while Conservative Stanley Baldwin was Prime Minister, its outcome might have been very different. But on October 18, 1929, Lord Sankey ruled that Canadian women were indeed persons with all the legal rights of Canadian men. Never mind what the drafters of the British North America Act had intended back in 1867. Sankey said Canada's constitution was a living tree, capable of growth and expansion within its natural limits, and in, quote, a continuous process of evolution. I do not tell this story because the famous 5 were unalloyed heroines. I tell it not despite the fact that they were deeply, deeply flawed, but because of it. Let us understand. Emily Murphy was an outspoken, vicious racist who opposed Chinese immigration, Black immigration, Jewish immigration, Ukrainian immigration. If she'd had her way, my grandparents would never have been allowed into this country. Nellie McClung was considerably more sympathetic to new Canadian immigrants, and Henrietta Muir Edwards actively campaigned for First Nations women to have the same legal rights as white women. But just like Emily Murphy, both McClung and Edwards believed passionately in eugenics and in the coerced sexual sterilization of those they deemed unfit to breed. So did Irene Parlby, who was actually a cabinet minister in the Alberta government, which brought in the shameful Sexual Sterilization Act, which remained the law in Alberta until Peter Lougheed and his Attorney General, Merv Leitch, abolished it in 1972. All 5 of these crusading women were imperialists and colonizers, classists and racists, who fought fiercely for the rights of women who looked and sounded like them, and were not so enthused about rights for others. If they'd walked down White Avenue in 1929 and passed my paternal grandmother, Risa Hardashnikov-Simovich, I doubt they would have invited her in for tea. Still, because of their fight, I get to sit in the Senate representing all of you. And that's not their only legacy. In 1982, Canada adopted a Charter of Rights and Freedoms, a formal written document of what must have seemed at the time like a complete list of enumerated rights. And some might have wondered if the living tree principle still mattered. Then, in 1991, Delwyn Vreen, a 25-year-old lab instructor at King's College in Edmonton, was fired from his job for being gay. He filed a complaint with the Alberta Human Rights Commission. Now, back in 1972, Alberta's original Bill of Rights, the one introduced by Merv Leitch, didn't say anything about LGBTQ rights. The Individual Rights Protection Act, which Alberta also adopted in 1972, didn't say anything about discrimination on the basis of sexual orientation. And so Alberta's Human Rights Commission, which was also founded 50 years ago this year in 1972, told Delwyn Vreen he had no case. Vreen took his argument to the Court of Queen's Bench and won a sympathetic hearing. Madam Justice Anne Russell ruled Alberta's human rights legislation was unconstitutional. But the Alberta government appealed. Now, let's open another nesting doll. In one of those strange historic ironies, the Court of Appeal panel was led by Mr. Justice John McClung, the grandson of Nellie McClung. But this McClung was no Living Tree fan, and he wasn't all that sold on the charter either. When Delwyn Vreen's lead counsel, Sheila Grekel, was speaking, McClung actually swiveled around in his chair, turning his back on her closing arguments. And his written judgment in the case dripped with disgust and disdain. The Alberta legislature, he wrote, shouldn't be dictated to by federally appointed judges brandishing the charter. He didn't stop there. I am unable to conclude that it was a forbidden, let alone a reversible legislative response for the province of Alberta to step back from the validation of homosexual relations, including sodomy, he thundered. Now, if Sheila Greckle and her co-counsel Doug Stollery had been content to leave things there, Justice McClung's fiery judgment might have been the last words on LGBTQ rights in Alberta for a long time. Instead, Greckle and Stollery raised funds, found a coalition of legal allies, and appealed to the Supreme Court in Ottawa. And in 1998, Canada's Supreme Court said it didn't matter what the Charter of Rights and Freedom didn't include sexual orientation when it was written in 1982. It deemed sexual orientation an analogous ground, analogous to race or gender or religion. The judges said our Constitution was still a living tree, and that we in Canada had effectively grown and evolved to the point where it was unconstitutional to discriminate against queer Canadians. And they read into the Charter and to Alberta's human rights legislation a new protection against discrimination based on sexual orientation. Thus, the legacy of the persons case isn't just that it established that middle-class Anglo-white women were persons. Eventually, it ensured the equal personhood of all Canadians, regardless of gender, race, religion, disability, sexual orientation, or gender identity. As for being on the right side of history, well, Sheila Greckle, who was treated so disrespectfully by Mr. Justice McClung, ended up sitting herself as a member of Alberta's Court of Appeal. And Doug Stollery, the shy solicitor who found his voice and gave the moving closing argument before the Supreme Court, well, he ended up as a chancellor of the University of Alberta. And as a footnote, two other young Alberta lawyers who appeared as interveners in this case at the Supreme Court, Ritu Kular and Julie Lloyd, they're both now judges too. But wait, because this story's not over. We have some twists and turns, more dolls within dolls. In the wake of the decision, Premier Ralph Klein came under immense pressure from some in his party and in the province to invoke the notwithstanding clause to perpetuate legalized homophobia in Alberta. Yes, the notwithstanding clause, the same workaround that Peter Lougheed and Merv Leitch had helped to place into the Constitution back in 1982 as a key part of the provincial-federal compromise. I remember covering the story of the Vreen decision for the Edmonton Journal, which had, under the moral leadership of publisher Linda Hughes and editor-in-chief Murdoch Davis, argued passionately against invoking the clause. Tensions were high. We didn't have Twitter or Facebook back then, but the city and the province were humming with anger and anticipation, waiting to see what would happen next. In the end, Premier Klein pushed back against the right-wing voices in his own caucus and his own cabinet. People close to him told me later that he was moved in part by the wave of nasty homophobic letters, faxes, and phone calls to his office. He was, I've been told, genuinely appalled by some of the hateful messages and said he had no idea that gay Albertans faced such blatant hatred. It is another accident of history, though, that one of his closest political advisors and confidants happened to be a queer woman. And because Ralph Klein had at least one close gay friend, he himself was able to put a human face to a political and philosophical decision. If Alberta had had a different conservative premier, if Ralph Klein had not had a lesbian advisor, the story of Delwyn Vreen might have had a very different ending. But the notwithstanding clause worked, and worked just the way it was supposed to. It gave Ralph Klein, the democratically elected premier, the final political decision. He could have used the clause to veto the Vreen ruling within Alberta, but he made a fundamentally political decision not to invoke the clause, and the legislature remained supreme, just as Merv Leitch and Peter Lougheed had intended. But wait, now I'm going to open up another doll. Remember the Eugenics Act, the one so loudly championed by Emily Murphy, the one passed by the UFA government in which Irene Parlby was actually a cabinet minister, the one finally repealed by Leitch and Lougheed? Well, in March of 1998, just 1 month before the Supreme Court's Vreen decision, the Alberta government actually had invoked the notwithstanding clause in an attempt to stymie Albertans who had been victims of the Eugenics Act and wanted to sue for redress. The Klein government had been spooked when Leilani Muir, who had been sterilized as a teenager without her consent or knowledge, successfully sued the province and was awarded a judgment of more than $740,000 plus costs. In an effort to head off more expensive lawsuits and to save millions, the province preemptively invoked the notwithstanding clause to stop other victims from suing and capped their damages at $150,000 a person. The public outcry was instantaneous and led again, if I may say so, by the Edmonton Journal. Less than 24 hours later, the province had backed down, and Ralph Klein personally apologized. This was presented to caucus in pure legal technical terms, and yes, my political sense probably didn't click into gear, Premier Klein told reporters. It became abundantly clear, he added, that to individuals in this province, in this country, the Charter of Rights and Freedoms is paramount, and the use of any tool to undermine the Charter of Rights and Freedoms is something that should be used only in very, very rare circumstances. So here's the question. Was Premier Klein especially reluctant to invoke the notwithstanding clause in Vreemd, given the extraordinary public revulsion at his attempt to use it against eugenics victims less than a month before? I suspect so. And so in this strange way, the fight for the rights of victims of eugenics also helped to ensure the rights of gay, lesbian, bisexual, trans, and two-spirited people in Alberta. In the end, the province settled 800 claims by sexual sterilization victims at a total cost of $142 million, a sum that in no way recompenses the true human cost of Alberta's obsession with eugenics, but a sum to remind us that the famous five had some truly infamous ideas, and that the human rights legacy they leave us is a complicated one. But that's exactly the point I want to make. Our Constitution and our Charter were far from immaculate conceptions. Our charter rights evolved, and they keep on evolving. And they are as much a product of our mistakes and our injustices as they are of our better angels. In Mark Antony's famous funeral oration for Julius Caesar, Shakespeare has his character say, "The evil that men do lives after them. The good is oft interred with their bones." In the case of Emily Murphy, Nellie McClung, Henrietta Muir Edwards, Irene Parlby, and Louise McKinney, the good and the evil they did both marked our province and our Constitution forever. I'm going to take a sip of water, and then we're going to go to chapter 2. So here comes chapter 2, My Life as an Amateur Gardener. Thomas Jefferson, one of the drafters of the American Declaration of Independence, once wrote to a friend, "The tree of liberty must be refreshed from time to time with the blood of patriots and tyrants. It is its natural manure." Happily, taking care of Canada's living tree requires a lot less melodrama and a lot less manure, but it does take all of us to nurture our tree and keep it healthy. Now, does the living tree principle mean we can ignore the text of the BNA Act, the Alberta Act, the Constitution Act, whenever it becomes inconvenient? Of course not. But it frees us from the tyranny of literal originalism and allows us the privilege to exercise some common sense. In the United States, people often fetishize and romanticize the authors of the American Constitution. They place inordinate emphasis on what the framers might have meant, trying to read the minds of founding fathers such as James Madison and Alexander Hamilton. I sometimes wonder if American jurists of a certain type ought to be holding seances or bringing in Ouija boards and crystal balls to better interpret messages from the other side of the veil. In Canada, where our Charter of Rights and Freedoms is just 40 years old, we're less tempted to engage in hagiography. No one so far has written a rap musical about Roy Romano and Jean Chrétien. Many of the people who worked on our Constitution are still very much alive, and even the ones who are no longer with us are still very present in our memories. Our Constitution was written and shaped not by saints and philosophers, but by politicians and public servants, lawyers and judges, working out practical realpolitik compromises to help govern a diverse and complicated confederation. Moses didn't bring the charter down from the mountain on stone tablets. It's a living, evolving work in progress, as I'm here to testify. I was sworn into the Senate of Canada in late October of 2018, but that's not actually true. I'm not a religious person. I was never sworn into the Senate at all. I affirmed my oath while holding this copy of the Charter of Rights and Freedoms, the document I pledged to defend. I had only been a senator for a couple of weeks when the Senate faced a small constitutional crisis, and I was called to make good on my vow. It was just a month before Christmas, and workers at Canada Post launched rotating strikes. They weren't stopping the mail completely, but they were certainly creating stress and uncertainty for businesses shipping Christmas purchases, and for ordinary Canadians who wanted to send holiday cards and packages. But in an era of email and courier services, maybe a postal strike wasn't quite the economic or social catastrophe it might have been a generation earlier. And postal workers had a long list of significant grievances that they insisted were not being addressed. The Trudeau government nonetheless passed legislation to order the union members back to work. This was an emergency, and the Senate, which had just risen, was abruptly recalled for an emergency debate. It was at that moment that I, a raw rookie, truly came to appreciate the intellectual caliber of my Senate colleagues and of Senate discourse. For once in my life, I was speechless. I just listened as we tackled two separate but related constitutional questions. Was it constitutional for the government to order an end to a strike that had scarcely begun? Or did that violate the charter rights of union members? And if ordering workers back was a constitutional infringement, was it a serious enough violation of the charter for us as the unelected upper house to veto the will of the elected MPs? There was intense scrutiny on the Senate for another reason. When Justin Trudeau became Prime Minister in 2016, he had launched an audacious round of Senate reform, a subversive, quiet revolution of our upper chamber that did not require constitutional amendment nor provincial approval. 2 years earlier, the Supreme Court had told Stephen Harper in its reference decision that electing senators would require a constitutional amendment, which would in turn require the consent of 7 provinces representing at least 50% of the population. The court had further ruled that abolishing the Senate would require the unanimous consent of all 10 provinces, the House of Commons, and the Senate itself. So thanks to Stephen Harper's reference questions, Trudeau knew all the things he couldn't do. So he simply stopped making patronage appointments. First, he ejected all the sitting Liberal senators from his caucus. Then he set up a panel of arm's length experts, a panel like the sort that nominates judges. He allowed any Canadian citizen over the age of 30 to apply for the job of senator in an open, merit-based competition. And then he appointed everyone who came out of that process as an independent, so that now there are no Liberal senators at all. Now, maybe that doesn't sound radical to you, but once the majority of senators were freed from party discipline or party hierarchies, once senators weren't hand-picked party loyalists, but instead ornery free thinkers, the Senate had a new credibility and a new power, because the government couldn't rely on the new appointees to be a rubber stamp and vote the party line. The Senate does have the right and indeed the responsibility to veto blatantly unconstitutional legislation, but it rarely uses that power. The question was, would we do so in the case of the back to work order for postal workers? The senators who took to the floor that weekend for debate were a remarkable lot. They included Mark Gold, a former professor of constitutional law at McGill University and a professional mediator; Murray Sinclair, the respected First Nations judge who led the Truth and Reconciliation Commission; Pierre Dalphond, a former judge of the Quebec Court of Appeal, also an experienced mediator; Francis Lankin, a one-time union leader who would go on to hold several senior cabinet positions in the government of Bob Rae; Tony Dean, the former Deputy Minister of Labour in the Ontario government and the former head of the Ontario Public Service; Diane Bellemare, an acclaimed professor of labor economics, to give just a few examples. Also among my new colleagues was Senator Howard Whetstone, a former federal court judge. "I felt like I was back on the court making a decision," he said in his speech to the chamber. "Of course, I read the Saskatchewan Federation of Labor case, and I considered the Canada Post 2011 decision, and the school board case of Ontario, the BC hospital case, and I think I read some other cases on the right to strike and Section 2D of the Charter." Yeah, he just whipped that all out in passing, talking without notes, talking about how he had prepped for the debate, thinking of all the constitutional precedents as though he were back on the bench. And in that moment, I felt sort of the way I felt the first time my parents gave me the keys to their car and told me to drive my little brother to hockey practice. What was I doing here? Who gave me the keys to the car? Who thought I should be fiddling under the hood of the Constitution? When were they going to realize that my appointment had been a terrible mistake and that I wasn't worthy to be here? Feeling the weight of all this on my shoulders, I decided, for once in my life, to stay quiet and to bring to the debate the one gift that I did have, my skill as a reporter. This emergency debate happened over the weekend, and there were almost no reporters, I think none, in the Senate press gallery. And at that time, in November of 2018, we weren't yet live streaming the Senate. You could, if you were a real political wonk, listen to an audio feed of the debate, but that was it. And so I started to live tweet. It was a natural response. After all, I had live tweeted Edmonton City Council meetings and school board meetings and many debates in the Alberta legislature. I actually had no idea if I were allowed to tweet from inside the chamber, but I figured if I weren't supposed to be tweeting, someone would tell me soon enough. They didn't. So for hours, I summarized the debate for a growing online audience, and they were eager to know what was happening since I was pretty much the only source of information. I listened to Pierre Delphon and Murray Sinclair, deeply experienced former judges arguing passionately against the constitutionality of the back-to-work order. Then I listened to Howard Whetstone and Mark Gold, equally qualified experts, arguing with elegant specificity that this bill was indeed constitutional and abridged no charter rights. This debate took place in the old center block, in one of the last weeks that we would be sitting in that historic building before it was mothballed for a decade-long renovation. And it was freezing inside, literally, as snow blew right inside the hallways through the old-fashioned fake Gothic casement windows. How was I going to vote? As I walked the windy halls, I finally had a brainwave. I did what I'd done so many times in the past as a journalist. I called Eric Adams, Vice Dean of the University of Alberta Law School. After all, I reasoned, he was a professor of constitutional law and a professor of labor law and labor history. Professor Adams kindly walked me through all the labor lore, the constitutional conundrums, and I was profoundly grateful to have such a great source at my disposal. Although, like a good rabbi, he didn't actually tell me what I should do. It was more equasive, on the one hand, on the other hand. And then it was finally time for a vote, a standing vote where each senator in the chamber had to rise to say yay or nay. Because I was a very new senator, my seat was way far away from the speaker. And I would be one of the last ISG senators, the last independent senators called to vote. That gave me a unique liberty. I could see how others were voting before I did. And I could see that if I voted against the back-to-work legislation, it would still pass. I could vote my conscience freely in the sure and certain knowledge that I personally would not be provoking a constitutional crisis. And so I stood with the nays and voiced my opposition. In truth, it didn't take much bravery because by that time, I knew my vote would be largely symbolic. The final free vote, with no one whipped in the chamber, was 53-25 with 4 abstentions. But the Senate had done its job, debating well and voting freely, hashing out all the charter issues and all the public policy ones too. When it was all over and I was sitting in my desk somewhat shell-shocked, Pierre Delphon, who was always so courtly and elegant, leaned over and shook my hand. This was back in the before times when we still shook hands. We were on the right side of history, he assured me. And I felt just slightly queasy because there it was, history, constitutional history. And I was somehow falling through the looking glass, no longer an outside observer of the political process, but one of the people in the business of history making. Standing in the Senate, right where Emily and Nellie and Henrietta and Irene and Louise had fought so hard for me to be, right where Lord Sankey had confirmed that I belonged. Here I was, a fallible, flawed human being, just like all the fallible, flawed human beings who'd made constitutional history before me. Let me remind you of the ringing words of Sir Lyman Poor Duff, that long ago Chief Justice of the Supreme Court. Remember what he said? I will do my Sir Lyman Poor Duff voice. The duty of the court in every case is loyally to endeavor to ascertain the intention of the legislature and to ascertain that intention by reading and interpreting the language which the Senate itself has selected for the purpose of expressing it. That presupposes that the legislature has an intention, as though a legislature were some sort of being with a mind of its own, that it acts with clear intent and selects its language with exquisite care to last down the ages. I am here to tell you that this is not always the case, that sometimes amendments get drafted on the back of a napkin or hashed out in the Senate break room, and that legislation is a kind of ad hoc collective creation. Let me give the example of last year's Bill C-7, which amended Canada's medical aid in dying legislation to bring it closer to the Supreme Court's ruling in the Carter decision. In 2015, let's recall, the Supreme Court ruled that the provisions of the Criminal Code which made medical aid in dying illegal were unconstitutional. The court said that the provision violated the charter rights of Canadians under Section 7 to life, liberty, and security of the person. The Trudeau government eventually legalized MAID, but only in very limited circumstances, when death was reasonably foreseeable. But that wasn't what the Supreme Court had said in Carter. The case specifically involved the circumstances of two British Columbia women, Kay Carter, who had suffered from severe and painful spinal stenosis, and Gloria Taylor, who had had arterial lateral sclerosis. Neither woman had been dying. Their deaths were not reasonably foreseeable, but their suffering had been, in the words of the Carter decision, intolerable and irremediable. That was the test. So the government's legislation was challenged in court. The courts ruled that the new law was still unconstitutional. Bill C-7 was an effort to bring the law into clearer conformity with the Carter decision, and that was the bill the Senate had to debate. By this time in 2021, the independent Senate experiment was much further evolved. Under the new merit-based appointment system, well, it turns out when you appoint by merit, there were suddenly a lot more women in the Senate. The gender split is almost exactly 50-50. And I'd like to thank Lord Sankey and the famous five for that. I think they'd be delighted by that demography. We had by then formed ourselves into four distinct groups: the ISG, or Independent Senators Group, which is now the largest group in the Senate; the CSG, or the Canadian Senators Group, which is led by my Alberta friend and colleague, Senator Scott Tanis; the PSG, or the Progressive Senators Group; and finally, the Conservatives, who are now the only non-independent caucus. As of today, they have just 16 members, 16 party-affiliated senators out of a total of 105. But when it came to Bill C-7, the Conservatives were also unwhipped and voting freely. They were deeply divided between their classic libertarian members who didn't think Bill C-7 went far enough, and their social conservative members who felt it went way too far. If you think the Senate is a vestigial organ like the appendix, a useless and anachronistic constitutional appendage that you can safely ignore until it becomes inflamed and infected, I would implore you to read the transcripts of our C-7 debate. Powerful, thoughtful, passionate, nonpartisan speeches from all moral, cultural, and legal perspectives, as senators from every corner of the chamber made sophisticated constitutional and ethical arguments, often drawing on very personal family experiences. By that time, we had two new senators among us, two constitutional law experts, Judith Keating and Brent Cotter, who had been the deputy ministers of justice in their home provinces of New Brunswick and Saskatchewan, respectively. But we were also blessed to have among our number four gifted physicians. Rosemary Moody, a pediatrician and neonatologist from the world-famous Toronto Hospital for Sick Children, where she worked with many families dealing with end-of-life decisions for their infants. Marie-Françoise Mégy, a professor of family medicine who spent 7 years working as the medical director of a palliative care center that she herself helped to found. Mohammed Iqbal Ravalia, a former assistant dean of medicine at Memorial University and a longtime rural family physician. And Stan Kutcher, the former head of psychiatry at Dalhousie University, an expert in suicide prevention and the treatment of depression. The original bill included an absolute ban on medical aid in dying for people with psychiatric or psychogenic illnesses. And after much very passionate debate, we agreed as a group that a blanket ban on that type was a violation of the quality rights contained in Section 15 of the Charter and a policy which ran directly counter to the Carter decision. Then we passed an even more provocative amendment, one that provided for advanced directives for people who might fear their eventual loss of capacity to request MAID. The amendment was introduced by Pamela Wallin of the Canadian Senators Group, and I spoke passionately in support of it. And both Senator Wallin and I drew on our tragic experiences caring for mothers with Alzheimer's to ground our comments. Neither of us thought the amendment would stand. We thought we were simply putting our personal stories on the record. But to our surprise, and I think our delight, the amendment passed 47 to 28 with 8 abstentions. Maybe that had to do with Senate demographics. But I also wonder how many senators voted with their hearts on the assumption that the amendment would not pass. Did it sort of pass by accident? Well, maybe. I, however, prefer to say that it passed organically. We sent our improved version of C7 with several other amendments besides back to the House of Commons. The government was, how shall I say it, not happy. This was not what they had wanted us to do. So they offered us a compromise. Instead of banning medical aid in dying to those suffering with serious mental illness, they agreed to a 24-month sunset clause, giving them a set amount of time to come up with a MAID regime for psychiatric and psychogenic illness, one that would not lead to the exploitation of people who were vulnerable, suicidal, or in the grips of temporary depression. And they agreed to strike a committee to study the issue of advanced directives, a promise they're still in the process of keeping, but one where we're very much holding their feet to the fire. My point? Legislation is not written by one guy with a pen. There is no magic wizard in Ottawa who is the author of a new law. The Parliament isn't one person. And in our Reformed Senate, complicated bills that engage with the Constitution and the Charter are debated and amended and rewritten all the time. In this era of extraordinary political polarization and divisive online disinformation campaigns, I receive hundreds of emails a day from angry and frightened people who firmly believe that Canada has already become a dictatorship, where one prime minister can erase charter rights. Our bicameral parliament and our constitutional monarchy are replete with fail-safes and redundancies and checks and balances to prevent just that. I am fond of the French phrase for a new bill, projet de loi, a project. A new law is a project, and a group project at that. Most recently, the Senate has been in the spotlight, albeit briefly, due to our debate on the government's invocation of the Emergencies Act. The speeches, again, came from every corner of the Senate and covered almost every imaginable issue from a huge range of perspectives, with many senators from all 4 groups articulating their deep ambivalence about the decision to invoke the act in these difficult circumstances. We debated steadily for 2 days, for more than 14 hours, until we were abruptly interrupted by the news that the government was revoking the powers of the act. Now, part of me was relieved that such a decision wasn't going to fall on my shoulders and on our chamber. But there was, if I'm honest, also a strange sense of anticlimax, even disappointment that we'd been made sort of redundant. On Twitter, I likened it to doing all the preparation for a colonoscopy, only to have it canceled at the last minute. But maybe for a legal audience, it's better to say that it was like being a jury or a judge sitting through a whole trial only to find out that the 2 sides had negotiated a plea or a deal before you had to decide. I saw Twitter and Facebook and even conventional media reports filled with somewhat imaginative speculation that the Prime Minister only lifted the Emergencies Act because he feared it was about to go down to an embarrassing defeat in the Senate. However, having listened to and live tweeted the speeches of every senator who spoke, and knowing who was still left on the order paper, my well-informed best guess is that the motion would have passed. There would have been senators from all 4 groups who voted against it for a variety of reasons. But at the end of the day, I think the Senate still would have endorsed the motion. How lucky we were during that debate to have amongst us in the Senate that week remarkable colleagues, such as Senator Bev Busson, a lawyer who was the first female officer in the RCMP and the first woman to serve as RCMP commissioner. Senator Gwen Boniface, a lawyer and a former commissioner of the OPP, who's also worked for the United Nations as an expert in transnational organized crime. Vern White, the former chief of the Ottawa Police, and David Arnott, a former Crown prosecutor, a former judge, and the former chief commissioner of the Saskatchewan Human Rights Commission. And yeah, I'm name dropping again, both because I'm so inspired to sit in the Senate with such remarkable colleagues, but also because cynicism about the Senate is so pervasive, so toxic, and so tired. It's based on outdated grievances that don't take into consideration the radical transformation the Senate has undergone in the last 5 years. I want you to understand how remarkable my Senate colleagues truly are. The decisions of the Senate are not based on academic articles about legal theory. They aren't dictated by the government or the House of Commons, and they aren't predicated on party loyalty. They are based on the combination of the expertise and lived experiences of the senators in the chamber. When we analyze charter statements, when we ask if proposed laws can pass the Oakes test, or if they are saved by Section 1 of the Charter, we are applying the law not as legal theologians, but as practical pragmatists looking for workable compromises. We meet these days in the old Ottawa railway station. It's been totally renovated, but our new Senate of Canada building is the self-same building where the Constitution and the Charter were hammered out 40 years ago. And we take those responsibilities as the guardians of those documents seriously. I don't believe in fate. I don't believe there is a divinity that shapes our ends, but I am intrigued, even excited, by the random accidents of history and by the accretions of chance that gave us the Constitution we have today. If Ramsay MacDonald hadn't won his minority election and appointed Lord Sankey, equality for women would have taken much longer in Canada, and we wouldn't have a living tree principle at all, and the fight for queer rights in this country might have been much longer and harder. If Peter Lougheed hadn't defeated Harry Strom and appointed his good friend Merv Leitch as Attorney General, we might not have had the repatriated Constitution with its notwithstanding clause. If Pierre Trudeau hadn't married Margaret Sinclair, well, we might not have a reformed Senate. And without the extraordinary courage of ordinary citizen plaintiffs, such as Henrietta Muir Edwards, Leilani Muir, Delwyn Vriend, Gloria Taylor, and the whole Carter family, our living tree wouldn't be nearly so lush or vibrant. Maybe in some other mirror universe, some other quantum reality, some other timeline, Canada doesn't have this charter or this Constitution at all. But on this 40th anniversary, we should take a moment to celebrate the happenstance and accident, as well as the hard work and vision that brought us here in our own particular version of the multiverse. Our old friend Lord Sankey was a man with a genius for metaphor. He was also the judge who gave us this line from one of his more famous criminal judgments. Throughout the web of the English criminal law, one golden thread is always to be seen, that it is the duty of the prosecution to prove the prisoner's guilt. So let me appropriate a meme from Baron Sankey. Throughout the web of Canadian constitutional law, one quicksilver thread of coincidence is always to be seen, reminding us that our Constitution is not a static monument nor holy relic to be venerated, but the homespun handiwork of hundreds of individual Canadians, each committed to our experiment of democracy and diversity. Canada's coat of arms contains the following Latin motto: Desiderentis Meliorem Patriam, which roughly translated means, they want a better country. I love that motto because it is so aspirational. It acknowledges the work we still must do together to make this country better. The text comes from Hebrews 11:16. But now they desire a better country, that is, an heavenly. Wherefore God is not ashamed to be called their God, for he hath prepared for them a city. Again, I am not a religious person, and the New Testament is not my testament. Canada, though, is a work in progress, still far from heavenly. The Charter of Rights and the Constitution are testaments to our efforts to make this a better country, and a reminder that we are all of us as citizens, called to do our part and to do our best to make this a better country. Because the Charter isn't an end, it's a beginning. And our tree is still growing, leaf by leaf, branch by branch. And all of us are its gardeners. Thank you, merci, and hi.
Senator, wow, that was extraordinary. You wove together history and politics and constitutional philosophy and the rule of law in a way that I don't think anyone else can. So that was extraordinary. On behalf of all of us, thank you so very, very much.
It was an honor and a privilege. I think I may have talked too much.
No, on the contrary, on the contrary. Now, friends, it's my delight to introduce two students who will be moderating a Q&A session that the senator has graciously agreed to take part in. I will ask you on behalf of the students, if you've got questions, put them in the Q&A box rather than the chat box, please. And these two students will make you appreciate why Dean Billingsley and I said that we were so proud to work with the Leitch family and the Lougheed family to support students, in addition to hosting lecturers like Senator Simons. And the students are from the two law schools, from the University of Alberta, a second-year student named Lee Klippenstein, and from our law school here at Calgary, a third-year student named Flutra Kachuri. So Lee and Flutra, over to you.
Good afternoon, everybody. I want to say thank you to Senator Simons and to the Leitch family and all of the donors, as well as both law faculties. So yeah, please get your questions into the Q&A and we will get them to the senator as soon as we have. And there is one in here right now. So I will start with this. Senator Simons, there are now 15 vacancies in the Senate, the longest of which dates to November 2019. At what point does the volume or duration of vacancies affect the Senate's ability to function or the quality of its work?
I think we've already reached that point. I'm quite cross about this. We've had a Senate vacancy in British Columbia. I actually thought it was earlier than November. I think it's August of 2019 that Richard Neufeld, Conservative senator from BC, retired. So BC, which only gets 6 senators, has had only 5 senators since before the pandemic. Alberta, which only gets 6 senators, is down to 4. Prince Edward Island, which gets 4 senators, is down to 2. So I think this is a problem, and I think it's a significant problem for the West, because Alberta and British Columbia are already underrepresented significantly in the Senate, and the fact that BC and Alberta have been short senators for this long is upsetting to me. I was very happy to welcome my new Alberta colleague, Karen Sorensen, the former mayor of Banff, who joined the Senate a couple of months ago. But I would like to send a message to the Prime Minister through all channels possible. I understand that there have been a lot of other things going on. There's been a pandemic, there's a war in Ukraine, there have been a lot of other crises. But the Senate, to do its job well, needs to have as close to a full complement of senators as possible to get that diversity, and especially that regional diversity, which is so important to our work.
Thank you for that. Just one moment here. We have another question. The question is, what, if anything, can be done to maintain our reformed independent Senate beyond a change in government?
That is a really, really good question, because although I applaud the Prime Minister for the ingenuity and the creativity of his reform project, it is thus far in no way enshrined. It was his personal choice to do this. And if the government were to fall tomorrow, which is less likely today than it was yesterday, a new prime minister from a different party could adopt a different system. What we need to do sooner than later is to pass amendments to the Parliament of Canada Act that would enshrine the idea of having an independent, nonpartisan Senate. And again, I'm not happy that the government has taken this long to do this. It's been very frustrating for many of us in the Senate. And I do hope, and I say this, I mean, please don't think I'm being coy. I've never met the Prime Minister. I'm a member of the Senate. I'm an independent senator. Sometimes I get to speak to cabinet ministers. I reach out to them. I spoke to Seamus O'Regan, the Labour Minister. We were in contact all over the weekend talking about the CP Rail Teamsters labor dispute. So it's not that I am divorced from what happens over there, but I don't have a pipeline to the Prime Minister's office. I would strongly encourage the government and anybody from the government who might be listening to do what you can to make these Senate reforms something that is ongoing. At this point, though, even if the government were to fall tomorrow and there were to be a new prime minister, there have been an extraordinary number of independent senators appointed, and it's pretty hard to unscramble that omelet. And Lee and Flutra, if you have questions while you're waiting, I mean, I know that you are brilliant award-winning law students, so you can sneak in some questions of your own. I know how this will be. People are shy off the top, and then at the end there will be 20 questions in the queue and people will be sad. So
yeah, I think your prompting there has got some more coming here too. This one says, I believe that Quebec's Bill 21 offends against the charter. What is your view and how should that be addressed?
I am appalled by Quebec's Bill 21. For those of you who, you can get lost in the thicket of all these numbers. So Bill 21 is Quebec legislation that banned people who wear a yarmulke, a hijab, a turban from holding certain roles in the public sector. It originally was a much broader ban, but now it's specifically teachers, judges, police officers. I forget all the categories, but it's not quite as broad as it used to be. I was one of a group of senators of Jewish, Sikh, and Muslim descent who signed a joint letter denouncing Bill 21. To me, I'm not a practicing Jew. My father was Jewish, but to me, the idea that you concoct a law that specifically discriminates against Muslims, Sikhs, and Jews in 21st century Canada, and I have a lot of, I have a lot of very dear friends who are Quebec senators. I understand that in Quebec this is viewed very differently, but for me, this is not a complicated question. The question is, what can the Senate do about it? Which is, apart from write letters and speak out publicly, not much, because this is provincial legislation. It doesn't come before the Senate in any way. So we can exercise some moral leadership and some moral suasion, but that is sort of the extent of what I can do. I can tell you, I was really touched right after Bill 21 passed. It was, or not long after, it was Read-In Week in Edmonton, where I visit many schools to speak to students and read to them. And I was really struck by the number of junior high and high school students who were outraged about Bill 21, a Quebec piece of legislation. But to them, it really hit home. It was legislation that said that people like them were second-class citizens in one part of Canada. And I don't think that that's something that should be allowed. But there's our friend, the notwithstanding clause.
Thank you. We have another question here from an attendee, and it relates to the independent senators as well. Can you please elaborate on the significance of the decision to set up an arm's length panel and appoint independent senators, ? And whether there are any implications to that?
Yeah, so I mean, up until 5 years ago, senators were patronage appointments. And I don't say that disparagingly, because Alberta has been gifted with some really remarkable senators. People like Ron Gitter, Tommy Banks, Elaine McCoy, Thelma Chalafoud, Jean Forrest, Claudette Tardif. I mean, we've had some amazing senators from Alberta. Doug Roche, I won't give you the whole list. And some of those appointments were really quite inspired. I mean, Elaine McCoy was a progressive conservative cabinet minister in the provincial government in Alberta, who was appointed by Paul Martin, a liberal prime minister. And she was the founder of the Independent Senators Group. So we've got a long track record of maverick senators from Alberta. But you can see with patronage appointments, there's always a risk that whoever the prime minister, he or she might be, will appoint friends, cronies, donors to the party, people who are owed political favors. So the idea of having it be independent was to open it so that people, you didn't have to be a political actor to have a chance to be a senator. So now anybody can apply. Anybody over the age of 30 who is a Canadian citizen and who owns $4,000 worth of real property. It's the same property provision that was put in the BNA Act in 1867. So you had to be super rich to own $4,000 worth of real property in 1867. Now, I think in Vancouver, $4,000 gets you like this much, but that's the only criteria. And then it's based on merit. So the idea is to have it as apolitical and as nonpartisan as possible. So we have had on that selection committee, I think both the former president of the U of A and a former president of the U of C have served on that selection committee at various times. Melissa Blake, the mayor of Wood Buffalo, has served on that selection committee. So the idea was to try to get people who were not politically partisan themselves and who were people of gravitas and, you know, people who had some sense of, you know, who should be called upon to be a senator. It is an imperfect system because any arm's length committee is only as good as the length of its arms. And so the people who are appointed are those patronage. I mean, you know, you could have a mise on a beam of turtles all the way down. You can't have an independent selection committee to appoint the independent selection committee to appoint the independent selection committee. At a certain point, politics does come into play, as with the judges' appointment selection panels. The other thing it's really important to stress is that the prime minister of the day makes the final decision. And I think that's appropriate because somebody has to be held responsible if a senator who is appointed is corrupt or unconscionably lazy and just doesn't show up. So, I mean, at the end of the day, the prime minister has to wear the responsibility for making the final appointment, but he's given a very short list from which to choose. So I can tell you when I applied, you have to write an essay about why you think you would be a good senator. So that was lucky for me. I'm good at writing essays. You get 3 to 5 letters of recommendation. Everybody has a different strategy. I decided I would get 3 letters from people who were completely apolitical, not connected to the Liberal Party or the Progressive Conservative Party or any conservative party, just, you know, 3 letters from people who knew me in various facets of my professional life. And, you know, you have to answer a bunch of skill testing questions. Eventually you have to pass a security background check to make sure that you're neither a spy nor likely to be blackmailed by spies. It's very exciting. And I applied and heard nothing for 7 or 8 months. And I thought that, you know, oh, well, that was fun to apply. It was good for my ego to read my letters of recommendation. But when I did get the call, it was quite a shock. And I said to the prime minister, I feel like a dog who chased a car and then caught it. So.
Thank you, Senator. There's a brief gap in questions, so I have one for you. I think
go ahead.
I don't want to put words in your mouth, but I would say that that you are a fan of the living tree approach over originalism. I'm curious what you think the extent of that is. Like, where does that stop?
Well, that's a really good question because, you know, do you want to say, oh, well, we've decided the Senate's no good anymore, and so we'll get rid of it. Living tree, time to prune. This is an interesting question. I think that what we've seen in the case law, in both the Persons case and the Vreen decision, gives us some suggestion of where the boundaries are, which is to say, looking at an expansive and generous view of charter rights, as opposed to, you know, some of the other nitty-gritty of the constitutional machinery. So I think that it's with that sense of, you know, the long arc of history bending towards justice that I think it makes the most sense. The trouble, if I'm being honest, is that I can be hoist on my own petard. And if social mores change and we enter into a more conservative phase of government and public life, am I comfortable with a world in which we can decide that we go backwards? I am not comfortable with that, but I grant you that I leave open that door.
Thank you. One of our award winners, Brooke Mante, has a question. How do you believe protecting the Constitution's living tree interpretation affects language rights, specifically in minority contexts, beyond simply just the protection of minorities in Section 23 of the Charter?
Well, I think it depends if you're talking about French and English rights versus Indigenous language or other heritage language rights. I would say that the protections for minority language rights when we're talking about English and French are well enshrined. And we are about to receive an amended Official Languages Act, which will look to that. And I've been meeting with representatives of the Francophonie outside Quebec, who are particularly keen to see enhanced protections for the French language in places like Alberta and Manitoba and New Brunswick and Ontario. And so I think it is really important that we be very clear in the Constitution that those two official languages have that protection. It's tougher in Quebec because protection for English language rights in Quebec runs up against the political exigencies of the fact that no federal political party is interested in going to war with Quebec about the fact that English language rights in Quebec may not get the same protections as French language rights in New Brunswick. So that is some of the realpolitik of that. This leads then to the interesting question of languages other than French and English. And there's been a lot of discussion in recent years about what should be the protections according to, say, Inuktitut in Nunavut and the Northwest Territories, where it is still very much a living language, spoken as a first language by many people. Should there be special protections in the Charter for Inuktitut? If they're there for Inuktitut, should they be there for Cree? If they're there for Cree, should they be there for Black? As you go along and down, this raises really interesting questions about how we perceive the paradigm of our country. What is the matrix on which we are built? I mean, when I was growing up, we heard about the two founding nations, the two founding languages. If you ask my Indigenous colleagues in the Senate, they are deeply offended by that language. They say they are the founding nations, and everybody else is a Johnny-come-lately, and who can gainsay them? I mean, they're absolutely right. So I think this is still a conversation we need to have. As for other languages, I mean, we're really lucky in Alberta. Not everybody knows, and I want to give, I give lots and lots and lots of props to Peter Lougheed, who dragged us into the 20th century and who passed Alberta's first multiculturalism legislation. But multiculturalism actually predated Lougheed and was an idea that Harry Strom, of all people, poor forgotten Harry Strom, championed. And I think it's really important to note that in Alberta, we have long championed the idea of multiculturalism and multilingual funding for multilingual schooling, so that we have robust, Ukrainian bilingual and Arabic bilingual and Spanish bilingual, and I think now Tagalog bilingual, and all of these other programs, which are not constitutionally protected. But I think that Alberta has been in the vanguard of recognizing that as a multicultural country, people come here with mother tongues that are not French and English.
Okay, the next question we have here is, as we see a Supreme Court in the US that is stuck in the seance mind reading of what the framers were thinking, why do you think Canada and Canadians generally have accepted the living tree argument? And if you really want to get into detail, when will the courts recognize the legitimacy of municipal governments which have no constitutional recognition?
Well, these are two separate but equally important questions. I mean, it is one of those accidents of history. I mean, if Lord Sankey hadn't been the Lord Chancellor, if Lord Sankey hadn't written that decision, if Lord Sankey hadn't been a great writer with a gift for metaphor and a champion, I mean, he went on to draft, I think it's the Declaration of Rights that was part of the League of Nations. So he was really a revolutionary thinker when it came to understanding civil rights and civil liberties. If it hadn't been for the fact that we had Lord Sankey and his living tree metaphor, we might have had a very different constitutional history. And it is fair to argue that Lord Sankey was an imperialist colonist. I mean, it is kind of outrageous if you think about it, that one of our foundational constitutional principles didn't come from a Canadian court at all. It came from a British court. I mean, it is kind of wacky. And I will acknowledge the hypocrisy that if that ruling had been very conservative, I would have spent the last years of my life fighting against it and arguing that it was outrageous that Britain could impose its imperialist yoke upon us as late as 1929. So I am at least aware of my logical failings. But I think that, if it weren't for Lord Sankey, we might have had a very, very different and much more literalist constitutional history. I don't know if we ever would have been quite as literalist as the Americans. I think there is an American talent for hagiography, for their, they think about George Washington and Alexander Hamilton and Thomas Jefferson in a very different way than we think about Sir John A. Macdonald and Alexander Mackenzie. I think Canadians just generally temperamentally don't make heroes out of their politicians and their founding fathers. And I don't just think that's because our founding was 100 years after theirs. I think there's something, I don't know, I think it's got to do, if I'm blunt, with the number of Scottish people who settled this country. I think the Scots are a lot less enamored of that kind of hero worship. And I think there's a lot of Scottish DNA in Canada's political culture and in our constitutional history. So I think that's why we don't make a fetish out of the text in the same way. As for municipal governments, some of you may know that I have recently launched an inquiry in the Senate about the role of municipalities in Canada. I suspect the person who asked this question knows that I launched that inquiry. We're gifted in the Senate right now to have a lot of former mayors. I mentioned Karen Sorensen from Banff. There's also Bernadette Clement, who's the former mayor of Cornwall, Ontario, and Eric Forêt, who's the former mayor of Rimouski. And they've joined with me in this sort of campaign in the Senate to focus more attention on the rights and responsibilities of municipalities, and the fact that municipalities are still very much caught up in this feudal relationship as children of the province. It ill behooves me to comment on provincial political affairs, but I could not help but note that a recent member of the provincial government referred to municipalities as children who need to be spanked. And leaving aside the political incorrectness of that metaphor in all kinds of ways, I do not think that in a country where we have cities of 1 million plus people, that it makes any sense to deny municipalities, which are on the front lines of so many important public policy decisions, any kind of agency. And if municipal government acts can be amended at a whim to take away rights that cities have exercised responsibly for years, I think that's really problematic.
We have a question from an attendee looking for your opinion, an educated guess, quote unquote, whether they're wondering where the use of the notwithstanding clause will go, whether it will be more common and accepted 20 years from now.
I think the thing about the notwithstanding clause, when I look at Bill 21, I think, oh, Merv Leitch, Peter Lougheed, what have you done? What were you thinking? How could you put something in the Constitution that allows the Quebec government to trammel on the rights of religious minorities in this way? I'm grumpy about that. But I think that what the examples I gave from the Ralph Klein period show is that a politician who cares about being reelected will be cautious about invoking a clause, which is sort of the nuclear option. When the Klein government, I think John Havelock was his justice minister at the time, when they did it in the case of the eugenics victims, I don't think, I take Premier Klein at his word. They didn't sit down and go, how can we make sure that people who were already victims of one of the worst crimes committed by the Alberta government cannot sue for justice? I think they really were thinking, well, that's a lot of money. Maybe we should figure out a way. And in the end, they did come to an agreement so that each individual person didn't have to pursue a damage claim. But I think, they got their fingers burnt. And it was a pretty powerful demonstration of the fact that you can overstep as a government and then that you can be held accountable. The challenge is when you're talking about minority rights, the majority might not always hold you accountable when you take away those minority rights. And we see that in Quebec. So I think that governments will continue to be very leery of using the notwithstanding clause as long as we, the voters and citizens, hold governments accountable. It only becomes easy to use if we allow it to be. And when I think back to the Vreen decision and the eugenics decision in Alberta, that was at a time when the Edmonton Journal had a huge circulation and a large public voice, and editors and a publisher who were willing to really speak out loudly in opposition to a government. In today's journalism universe, we're not in quite the same place. But I think it's actually incumbent on each and every one of us, which is why I said that thing at the end about how we're all gardeners of the living tree, which I grant you was pushing the metaphor quite a ways. But it is up to us. If you don't want your governments to invoke the notwithstanding clause, you have to be the one who says, no, there's a huge political price for that.
Okay, well, just as you predicted, Senator Simons, we're now at the end of our time, and there are several questions in the queue. So I think we will do one more, if that's okay with you.
Sure, yeah, I think if people are, we have 7 minutes. I'll shut up now and let you ask the question.
So this is about the Constitution more generally speaking, I think. So what do you think of replacing Canada's constitutional documents? How long do you think Canada should work with the two current documents before starting to draft new ones?
Oh, I don't think we should. I mean, drafting new ones, amending what we have, that's one thing. Drafting whole new ones, that's probably not a path we want to consider going down. I mean, this one's only 40 years old. I mean, I'm 57. I don't think 40 is that old. I think there's room for amendment. The challenge is that the amending formula sets an extremely high bar. 7 provinces representing at least 50% of the population is the standard amending formula. And provinces are very disinclined to act against their own interests. So say, for example, I'm grumpy that Alberta and BC only get 6 senators and that Nova Scotia and New Brunswick get 10. Is that fair? That's not fair. Are New Brunswick and Nova Scotia and PEI eager to give up some of their Senate seats to give them to British Columbia and Alberta? No. So that is the problem. I think, though, that governments have been leery of amending because it seems so difficult. And eventually the time will come that a government is going to have to bite the bullet and say, no, we actually do need to go back in and do some amendments. But for that, you're going to have a political consensus to get something passed, and that is not going to be easy. Now, Lee, you had one more thing you want to squeeze in, I think. Was it a toast to the award winners?
I think we were going to squeeze in just one more question.
Okay, one more question. Go ahead. One more question. I can do one more question.
Apologies. The question was, how does the Emergencies Act get revoked, but the government is still able to keep some part of it, in quotes, tools in their toolbox?
The Emergencies Act is revoked. It's just revoked, period. But people who were arrested under the terms of the Emergencies Act are still going to face the consequences of those charges. Tools in the toolbox, I think that was a reference to the whole issue of regulating dark money coming in through sites like GoFundMe and GiveSend. What is it called? GiveSendGo? I forget the name of the other one. And so I think there's been some discussion on the Commons side about how we need to figure out tracing money through those accounts. And that's not just for political reasons. That's for money laundering and, drugs and international spy operations about which we're suddenly much more alert these days. That's not going to happen automatically. I think what the government is going to have to do is it'll have to amend legislation, and that legislation will be debated and voted on in the House of Commons and then debated and voted on in the Senate. So it's really important to stress that the government can't just wake up and do things. All governments themselves sometimes fall victim to the delusion that they can just wake up and do things. And in some legislatures, that's easier than others. In a minority parliament with a strong Senate, it's much harder for any government to just wake up and change something.
Thank you.
Thanks, everyone. We're closing in on our allotted time. So I want to thank Lee and Flutra for moderating the question period. And Senator Simons, I want to thank you very much on behalf of the University of Alberta and the University of Calgary for the inspiring talk and I thought, an inspiring view into the window of how our Constitution evolves and continues to evolve. We will be sending you a acknowledgement of your
Oh, very nice. I will put it on the shelf.
we will try to get it to you in its current one body form and not have something that comes to you in pieces. I also wanted to thank again the Leitch Award winners, the Leitch family, and everybody for attending. And I'm going to pass the microphone over to Dean Holloway to give a few closing remarks.
Thanks so much, Barb, and thank you again, Senator, for a truly, truly wonderful, wonderful afternoon and wonderful Leitch Lecture. Thanks to everyone for coming. This is the end, and for this year, we'll see you 12 months hence, hopefully, back in person. Have a great afternoon, everyone.
Thank you all very, very much.